Let me start by asking you whether the Gujarat High Court verdict left you disappointed and dejected.
I said disappointed, which is, of course, a synonym for dejected, but not unexpected. And I think that now it's been going on for a while. I've appeared only in the High Court prior to this, but people know enough about it. But you should need to underline those 4 or 5 gross facts which made me call the judgment completely erroneous and unsustainable. And we are therefore very confident that the Supreme Court should interfere and rectify it. The first is, in the whole attempt to paint Rahul Gandhi black and therefore justifying a non-suspension of conviction, patent errors were made. Let me give you in simple, non-legalistic way for your viewers. Number one, there is a para there, 43, 45, etc. I don't want to get into details, which says this is moral turpitude. Now, everybody knows who has studied law, or even those who have not studied law, that a defamation offense has never ever been called a moral turpitude offense. Moral turpitude is a term of art. It's a technical term which is reserved for issues like rape, abduction, or particularly morally immoral crimes. Nobody has ever used it for defamation. So, just to make sure that the learned judge is elevating it to a stage where he need not grant suspension of conviction, he uses the test, the legal test, the erroneous legal test, the inapplicable legal test of moral turpitude. Second, the basic 2 or 3 questions are not answered, Barkha, in the judgment. What are the basic 2 or 3 questions? The most important was that assuming that the word Modi is a defined and non-amorphous class of persons, which it is not, by the way, which is the first argument, but let's assume that for a minute. Can a person who has actually been defamed by name, Barkha Dutt by name, Nirav Modi by name, Prime Minister Modi by name, Lalit Modi by name, can a person who claims to be defamed not file any defamation at all?
Well,
And
Sushil
can
Modi
any
has. Sushil Modi has in Bihar.
this is not the case of Sushil Modi where a conviction has been obtained. This judgment is bad because this is not, that's the on your own test, Barkha, what you just said. This conviction is bad because neither Nirav nor Lalit nor Prime Minister Modi filed. Can you hear me?
Yes, go ahead. Go ahead.
Can you hear me? Any
Yes.
person of that amorphous class, which by the way is pleaded to be approximately 13 crore persons. Anybody can stand up and file without showing prejudice, loss. Third, it has been proved on the record with material that a Modi, for example, a Modi from Punjab, a Modi from Gujarat, a Modi from my home state Rajasthan, or from Uttar Pradesh, has no connection to each other. There's not a defined amorphous community. I mean, non-amorphous community. No evidence is given to repel that argument. If it is not a community at all, how can any one person out of the 13 crore Modi surname people get up when the person, Mr. Prime Minister Modi, never files? Number 4, very interesting. A rarest of rare test is applied as if it's a murder charge. We are discussing, the learned judge in a particular para 4 times says serious, serious, serious. Now you are the legislature, Barkha. You don't consider it serious when you fix a punishment of 2 years. Do you fix 2-year punishment by the legislature of serious offences? In murder, in manslaughter, in rape? But the learned judge repeatedly uses the phrase serious. And let me tell you on the larger picture, Barkha, there is hardly ever, to my knowledge, and most criminal lawyers across the country, ikka dukka case ko chhod dijiye, hardly ever a case of conviction in defamation with a maximum sentence of 2 years. And a case where on that conviction of 2 years, you are disqualified virtually for 8 years unless the Supreme Court intervenes. Of course, in other countries, you do not have, in true democracies, political persons A filing against political person B for what is said in a campaign. And see, ask the larger question. There are 10 BJP functionaries, including Prime Minister Modi and Mr. Amit Shah, who have used very, very strong vituperative language in political campaigns from Karnataka to north to south. That is considered okay, kosher. Today, we are facing a defamation charge of 2 years maximum, which is treated with moral turpitude and very serious. So it's
Yeah.
an attempt really to emasculate democracy, emasculate free speech, emasculate I speak, if to send the message out clear. You speak, you express, you freely think, and I will put you down because I want to exclude you from parliament. The real test is that exclude you from parliament.
So hang on. Let me ask a question now. You say the High Court order is an order that emasculates democracy. In other words, you're suggesting that the Gujarat High Court judge who delivered this verdict wants Rahul Gandhi out of parliament.
No. I am saying the judgment based on the complaint by the political masters of this country is erroneous and unsustainable. The object of the complainants is to exclude Rahul Gandhi from politics, from temple of democracy. Let me ask you a simple question in answer. This great large community of 13 crore Modis is outraged according to both the complaint and the judgment accepts the complaint. But then why are all complainants, all I repeat, Barkha, mark my words, Jharkhand, Sushil Modi, the gentleman in Gujarat, all are only BJP office bearers. There is no other Modi who is aggrieved. So you are actually orchestrating a political campaign to exclude a man from parliament. That's what I meant. I have nothing to do with the judgment, which I am anyway calling it erroneous.
The judge says that there are 10 other criminal cases against the complainant, in this case, Mr. Gandhi. He particularly cites a case by the family of Veer Savarkar. How do you respond to that?
Very, very interesting. I'm glad you asked the question. Now, these are all errors, mind you. The questions you're asking are helping to bring out patent errors, not errors where I have to argue. Take your example which you gave, Barkha, which is 2 elements, 9 other cases and one name of Savarkar. Let's take them one by one. The learned judge mentions 9 cases. Does he add, and that's the error, that in none of them is he a convict? How can a conviction for which a stay is being sought refer to 9 other cases where he's merely an accused? It's an allegation. It has not been proved against Rahul Gandhi. So you are treating him as a serial offender in 9 cases, none of which have even a semi-conviction, leave aside a conviction. 1. 2. Savarkar is very interesting. The complaint in Savarkar case, these are the problem. The devil lies in the detail and people are not bothered about details. Savarkar complaint is filed in the end of April 2023. The conviction in this case is over in March 2023. So the learned judge in appeal of stay of conviction is referring to a Savarkar event which happened 1 month after this conviction, where it's again a complaint by a BJP person, BJP sympathizer, connected person, to say, look, so suppose today I go to the Supreme Court. Between now and the Supreme Court, you file a 5th complaint. The Supreme Court will dismiss me on the basis that Barkha has filed a 5th complaint against Mr. Singhvi. Are you following my point? So is it relevant? These are irrelevant. 9 cases are irrelevant. Savarkar is irrelevant. It's a post-conviction event.
Let me ask you this. A previous time when you and I were talking, you indicated that Mr. Gandhi personally almost considered going to jail and not fighting this protracted legal battle, and he had to be persuaded to do otherwise. Has the time come to ask that as a political question again? You're going to the Supreme Court now. There's going to be no quick judgment, maybe. I don't know. You would know better. Do you think 2 things? 1, Mr. Gandhi could apologize, cut his losses, get on with life, come back to parliament. 2, he could go to jail and make a political point.
No, first of all, let me correct you about your perception of what I said. I said Rahul Gandhi has never been scared of going to jail in a general sense. There have been other cases earlier, and he's been persuaded to seek bail. Otherwise, he was quite happy not to seek bail. I was not talking of this case. The problem with this case is different repercussions, Barkha, which I will emphasize. As going to jail is concerned, in a political activism case, Rahul Gandhi never hesitates to go to jail if he is to make a statement about the public which he is making. But here the problem is, number 1, they want to exclude him from the temple of democracy. 2, the exclusion they want is for 8 long years. 3, they want to exclude him particularly from campaigning in a political context and standing between now and 2024. Number 4, they want to inflict a premature election on the electorate of Wayanad, which wanted Rahul Gandhi at least till 2024.